Alex here with a legal nuts and bolts video on summary judgment. This is going to be a technical video. As with my other technical videos, I really can't simplify it. When I've tried to in the past, it makes it really long and people still struggle with it. So with these technical videos, you just have to do your own research. If I bring up a phrase you don't fully understand, I specifically recommend looking at your case law because I feel like that's where the wealth of information on summary judgment is going to be. That's where the examples will be, and that's where you're going to sort of see the little weird fringe areas, nooks and crannies of the law with respect to your specific state as to, I don't know, what perspective they have on that particular fringe area. Summary judgment is one of the most popular mechanisms that is used to end a case before trial. Not just popular, but one of the more successful ones. There's another popular one. It's the motion to dismiss for failure to state a claim. But that one isn't as successful as often as the summary judgment motion is. I did a separate video on failure to state a claim upon which relief may be granted if somebody wants to watch it. It basically allows you to end a case in the pleading phase. There's another video that I did called Judgment on the Pleadings, which allows the plaintiff to end the case instead of the defendant by basically saying that the answer that the defendant has filed admits the things that were alleged in the complaint. Since they were admitted, there's no point to going any further. Just end the case now in the pleading phase and give me my judgment. That one is not as popular, I hear. It is not as routinely filed, and I guess it's because it requires the defendant to just admit everything. So I feel like if somebody was going to admit everything, why even bother going to court? They would have probably just settled it before court. So anyway, that being said, the summary judgment mechanism, which is the third mechanism that I'm going to cover in this video, is not typically granted that early on. Typically, it's granted towards the end of the next phase, which is the discovery phase, or even after it, but before the trial phase is started. My understanding as to why is because what's being asserted in a motion for summary judgment is that there are no genuine issues of material fact for the court to decide on at the trial. And since there are none, the court could just make a decision now. Well, genuine issues of material fact are things that are going to be sort of narrowed down during the discovery phase. For anyone here who hasn't seen my videos on discovery, I have 7 different videos on them. Please watch those videos because you're not going to understand what I'm talking about. The part of the process, the discovery part of the process, is basically both sides probing each other for information. So it makes sense to me that summary judgment is granted towards the end or after, because that process itself could be used to narrow down the genuine issues of material fact. Each side can nail each other down on certain facts, or they may come to agreement on certain facts. By the way, that phrase, genuine issue of material fact, is not a magical phrase. Each word has purpose. The word genuine, the word issue, and the word material, those are not fluff words. They matter. And what I mentioned in the beginning of the video is this is a technical video. That's something that you're going to have to fully get your head around by doing your own research. But it's very logical. Just like with the other 2 mechanisms, this mechanism makes sense. If there are no genuine issues of material fact for the court to decide at trial, there's no point to going to trial. It's going to be a complete and total waste of time. The court can just make the decision now by applying the law to the facts that have been agreed upon, or that each side was sort of nailed down to. I'm really not sure that there's anything else I can mention with respect to summary judgment. I did research a little bit a long time ago on how divorce and family law sort of interplays with this specific tool. In Nevada, it appears to be forbidden. If I could remember the statute, I would talk about it, but I remember seeing statutes that expressly banned the judges in the family division from entering summary judgment in a divorce action or in a child custody action. I might be wrong, but that was just that's what I recall when I was looking into it. Another thing I will mention is that the summary judgment principles will often get applied in other areas of the law, even though the label summary judgment isn't being used. For example, in my video, landlord-tenant video, summary eviction for non-payment of rent, some of the case law that I looked into, at least in Nevada, with respect to how the court is supposed to analyze the whole summary judgment for non-payment of rent, or summary eviction for non-payment of rent. Some of the way that they approach it and look at it is also sort of the same way that they look at motions granting summary judgment, which is not to look and see if the tenant being evicted was right or wrong, so much as to look and see if there were genuine issues of material fact for the summary eviction judge to actually have to consider. And if so, then the tenant should not have been summarily evicted. There should have been a normal trial or evidentiary hearing or whatever. I'm not going to go into that right now. Please watch my video on summary eviction for non-payment of rent. And the same thing is sort of when it comes to like post-judgment motions in child custody cases. Let me stop there for a second. So my understanding is that there are 4 phases to these to lawsuits. The first is the pleading phase, which I talked about. The second is the discovery phase, which I also talked about. The third is the trial phase. And then following the trial phase is the post-judgment phase, which is typically really short in a normal lawsuit. Typically, the court will only look at things like cost awards and attorney fee awards for the person who won the trial, or who won the case if there was no trial. When it comes to child custody cases, the post-judgment phase is, especially high-conflict child custody cases, the post-judgment phase is enormous and it drags on forever and ever and ever with no end in sight. There are motions that are filed in that post-judgment phase, such as motions to modify child support, motions to modify custody and stuff, where even though the motion for summary judgment isn't used by label, the principles behind it are applied in those motions. So, for example, like I filed a couple of motions in my child custody case. They were post-judgment motions. One of them was a motion to modify legal custody. And even though I didn't use summary judgment by name, the principles behind it were still applied by the judge. The judge made rulings in my motion to modify legal custody, basically saying that there were no issues, there were no genuine issues of material fact for the court to really look into. And since there weren't any, the court was just going to summarily grant my motion right then and there without having to set an evidentiary hearing. So I just got the order in the mail, just saying order granting. Same thing with a few other issues that I brought to the court's attention in a post-judgment motion. And the same thing can go in the other direction. The court could just summarily deny your motion without setting an evidentiary hearing. So what I was trying to say is that there are sometimes areas of the law where summary judgment isn't used by label, but the principles behind it are applied, and the court will basically make a ruling without setting a hearing or a trial because there's no point to it, because there's no genuine issues of material fact for the court to decide. That magical phrase has a tremendous amount of meaning, and it's very logical. It just sometimes takes a lot of time for people to fully understand it. I think with that, I'm going to have to end this video. If anyone here has any questions on summary judgment, feel free to post it in the comments below. And with that, I will see you guys next time.